So we're going to start off by, I'm going to bring Michael in, and because, you know, there are a lot of misnomers about what a trust does and what a trust doesn't do, what a will does and what a will doesn't do. And so I get those questions all the time. And of course, I am not an attorney, and I don't even play one. And because we have a great attorney in Michael Brown to refer you to. So Mike's agreed to come in today, and he has spoken before at several of our client events over the years. And many of you have met Michael at some of our previous client events. In fact, many of you may even be clients of Michael's. So at this time, I'm going to turn everything over to Michael, and he's going to talk, he's going to do his thing. And after which, we're going to open it up for some Q&A. And then I'm going to provide you with a brief market outlook for the balance of 2020. The sectors that Raymond James feels offers the greatest opportunities for growth. All right, so with that, I'm turning it over to Attorney Michael Brown.
Thanks, Rod. I appreciate it. I appreciate the opportunity to talk to your clients and family. I hope everybody's hunkered down and staying safe and washing their hands all day. One good thing to look forward to, though, I think, and we need things to look forward to, but I was kind of realizing the other day that, you know, they're talking about bringing sports back. But they're actually talking about bringing all the sports back all at the same time. So I don't know about the ladies in the audience, but us guys, we're going to have baseball, football, basketball, soccer, hockey, and it's all going to be at the same time. So it's going to be a real interesting experience, at least for us guys. So, and then some of you ladies too, I'm sure. So what I want to talk about today, and I'm going to take maybe 20, 30 minutes of doing this, and then like Rod said, we'll open it up for some questions. But I want to talk about using a living trust in the real world. Now, I'm assuming that most people already have a trust, and you know, you've been to presentations where they talk about the benefits of having a trust, but I'm going to assume that everybody understands that. You know, we have a trust for simplicity's sake, to avoid probate, those kind of things. But what we want to focus in today is how it's actually used in the real world. And it's changed recently. Over the last probably 6 or 7 years, 5 or 6 years, mostly the financial industry has changed. So it's become we have to adapt to a different way of dealing with the different accounts that you have. So when I first started doing this 40 years ago, we used to be able to write letters to Merrill Lynch and Prudential and all the different companies, and we would request when we had a client that had a trust, and we would write a letter and say, please change this client's account. Please change it into the name of the trust, or please change the beneficiary on the account. And I would write up the letter, the client would sign it, and we would send it out to them. And the company would do whatever we requested of them. So it was pretty informal. And nowadays, after I guess 9/11 and all the security issues, everything has been sort of formalized a lot more than it used to be. So, and the issue with that is that each company now has their own form that they want you to use, and they won't accept the information from you in any other format. So if we try to write the same letter that we wrote before, all the company is going to do is send us back forms. So with my clients nowadays, I have to tell them, look, you have to go and get forms from the client, from the different companies, and basically you have to fill them out. So I can't really assist any longer in dealing with changing and attaching different accounts to the trust. For the most part, the client has to do that themselves. And there are some sort of technical things you have to understand in order to correctly fill out these forms. And one of the I think easiest ways to learn some of this stuff, and it is a lot of legal jargon, legalese, but I think with some basic understanding, you'll be able to deal with whatever comes your way in dealing with the different institutions, the banks, the mutual funds, things like that. So what I want to do now is I want to go through one of the forms, sort of a general form that a lot of the different places will want you to fill out and use. And that form is called a certification of trust. And what I want to try to do now, and I'm pretty new at this, but I want to put this on the screen for you so that you can take a look at it. And let's see if it works. Dun, 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 dun. Okay. Now I don't see me. Oh, there I am. Okay. Okay. So this is called a certification of trust, and this is a form that was actually created by the state of California. And you can see up at the top, that's the code section where you can pull the codes out and find it. And the purpose of this was to have sort of a shortcut way, a shortcut document that the client could put together and give to the bank or whoever they're dealing with, so they don't have to give them the entire trust. A lot of people don't like the idea of turning over their entire trust to the bank or whoever they're dealing, their financial institution. So having this little shortcut version seemed to make a lot of sense. So the government put it together, but they leave it to you to fill out. And it looks like a simple form, but there are some things you really got to pay attention to just to make sure that you're doing it right. The first part, name of the trust, that seems pretty simple. But what you really want to do is you want to make sure it matches exactly what is on your trust document. And that's true for any kind of name, your name, trust name, any names, they absolutely need to match all across the board. They need to match your trust needs to match your ID, especially nowadays, your ID has to match the names that you're using. I had a client last year who he was the successor trustee for his aunt. And when his aunt passed away, he went to the bank to get into the account to pay the bills, and his aunt had listed him as Larry Jones. So Larry went to the bank and requested the bank information. And when they wanted his ID, he pulled out his driver's license, and his driver's license actually said Lawrence on it. It didn't say Larry. And you would think, well, of course this is the same person. They knew the account number, they knew the bank, so they must have been involved. But the bank actually refused to accept it. They refused to accept Larry and Lawrence as the same person. Now, lucky enough that the documents that I draw up, they always say that a trustee at any time can resign and appoint a successor to themselves. So Larry ran over to my office, ran from the bank, came over here, and we wrote up a resignation, and Larry resigned, and lo and behold, Lawrence became the new trustee. So we were able to do a little fix on that, but you can't always. So it's just really important to get everything straight. So name of the trust, make sure you match it exactly that's on your documentation. Date of the trust, that should be simple. And then the next thing they want to know is who's the person that set up the trust? Who are the persons that set up the trust? And those persons have multiple names. So it depends on the attorney that writes the document. So you're either called a settlor, a trustor, a donor. I've even seen a trust maker. So when you look at your document and they want to know, and they come up with any of these, when they say, well, who's the, you can also add grantor. Who's the grantor? Who's the settlor? And again, that's the person that sets up the trust. That's you usually. The next thing they want to know is they want to know who the current trustees are. So trustees are the person or persons that are in charge of the trust. They run the trust, manage the trust. Again, you want to make sure that things are listed correctly and match. You know, we don't want a Larry Lawrence issue. The other thing I want to point out is a successor or a trustee in a trust is not an executor. I get an awful lot of clients that talk about being executors when they're really trustees, and it can confuse people, because an executor is actually someone that's appointed by the courts to be in charge of an estate. So if you're an executor, that's basically probate court, and it's the courts that actually appoint you as the executor. So don't call yourself an executor if you're not, because it just confuses people. But you are the current trustees. That's when you start off, you're the settlor, the grantor, you're the trustees, and you're also the beneficiary. So that's the third player in all of this. So if they ask who the beneficiary is, that's not necessarily the person that sets it up or the person in charge. It is a different position. It can be the same person. A lot of times, or at least at the beginning when you're doing a trust for someone, the person that's setting it up is also the trustee and is also the beneficiaries. But just make sure that you get them right. Very important. Okay, the other thing on the certification of trust is they want to know about multiple trustees. So they want to know if there's more than one, can one do it alone? Do we have to have unanimous consent? I always tell people it's better to have one trustee. I don't like multiple trustees if we can get away without having that. One of the problems that we have seen recently, where we have a couple of trustees, maybe mom and dad have two kids, so when mom and dad go, they want the two kids to be in charge. We don't want one kid to get something over the other one or take advantage. So we want them to do it together. Now, one of the problems with that these days is that you can't open up a joint bank account, or you can't open up a trust bank account with two trustees unless the trust says that either trustee can operate that account by themselves. So in essence, you can't have like a two-party type of an account. I know the old days, when I was in Little League, my dad was the treasurer of Little League, and when he would write checks, he would always bitch about the fact that he had to take it over to Joe's house, who was the president, and get Joe to sign on the checks with him. It took two signatures in order for that check to be good. And nowadays that doesn't exist. The banks don't have those kind of accounts anymore. They don't want to be responsible for making sure that there are two signatures on all the checks. So it's very important these days that if you have a trust with more than one trustee, that it also at least says that any one of those trustees can open up a bank account. Otherwise, we end up with having to have somebody resign and opening accounts and then adding them back on. I mean, there's some fixes to it, but it just complicates things, and you don't want to complicate if you don't have to. Okay, so the next part here has to do with revocability. So this one's a little tricky too, because it changes over time. So when mom and dad set up their trust, it's revocable. It's revocable, meaning it's changeable. So mom and dad can change it whenever they want. And a lot of times when the first one passes, when mom passes or dad passes, even the survivor has the ability to change things. So it's still revocable even after the first step, many times. There are some times where we make portions of the trust irrevocable. But for the most part, while either mom and dad are alive, the trust is changeable. Now, when mom and dad both pass, at that point, then the trust becomes irrevocable. It's not changeable by anyone other than mom or dad. So when they're gone, then it changes from a revocable trust to an irrevocable trust. And that kind of ties into the trust identification number, the next little issue that they want us to address. Now, while the trust is revocable with mom or dad, we can use either one of their social security numbers. That's the tax ID number for the trust. So mom or dad, it doesn't really make a difference. Now, when mom and dad pass away, The trust no longer can use their social security numbers. They have to have, or the trust has to have, its own number. So mom and dad pass away, the trust becomes irrevocable. And at that point in time, then you have to go to the IRS and they assign the trust a tax ID number. Now, one issue that has popped up that's kind of interesting is with this revocable, irrevocable issue is that if, dad's gone and then mom becomes incapacitated. And if mom is incapacitated, she can't change the trust. So a lot of people think, well, it's irrevocable at that point if mom can't change it. But the way the law looks at it, the rules look at it, is that as long as the person is alive, they still have the potential to make a change so that it is still revocable, even if the person in charge, even if mom doesn't have the capacity on her own to do that. So that one's a little tricky, pops up every once in a while. Okay, so then powers, usually you throw in a few trustees' powers on these things. If you're dealing with a form that's coming from an institution and stuff, you've got to be really careful on what they're asking you to list. Some of the institutions will ask you who successor trustees are. And that's a little scary to me because successor trustees change from time to time. I mean, if you set up a trust and you have young children, once those children, you put somebody in charge of their money for them, but then when they grow up, you would put the kids in charge of their own money. So you're changing who the successor trustees are over time. And most of these forms that you're dealing with say that you're responsible for updating the forms. And it's usually in very small writing in the back, but they're expecting you in a lot of these cases, if you update trustees, you got to update the forms at the bank. So, and I don't know really how to get around that one. If they insist on having that information to open an account, then you give them the information. I can't imagine that they would deny a successor trustee just because they weren't listed on the bank's records. But in any of these situations, you can always fix it. You can always fix things by going to court, but we're doing all this to avoid going to court. So it just, again, is sometimes a little tricky in how we have to deal with these things. So and part of the form is also just you declaring that the form is in full force and effect and hasn't been revoked and that kind of thing. The next part having to do with manner of taking title. So I get a lot of questions from clients as to, well, how do we indicate that our trust is the owner of this account? A lot of people tend to just put the name of the trust on the account. And that's really not enough. From a legal standpoint, what needs to be on the account or on the real estate, whatever we're dealing with, it needs to have the names of the trustees. So when you are opening an account or changing an existing account, the registration should be the trustees, so like mom and dad as trustees for, and then the name of their trust. So the trust name is on there, but we also want to make sure that the trustees' names are on there because legally the trustees are the owner of any trust account, any trust assets. As trustees, they can't benefit from that ownership. The ownership just allows them to manage the account. But bottom line, just make sure you're careful in how you do these kinds of things. Having an advisor like Rod can be helpful because if you can't figure it out, you just go back to Rod and say, what do I do here? And he's more than happy to help out on that stuff. So let's see, the rest of the form is just you saying, I swear under penalty of perjury, and then the document gets notarized. So that's the certificate of trust. That gives you some technical knowledge about how things are to be filled out. And the next thing, though, that I want to do is just go over how we then use this knowledge in conjunction with the different assets that you might have. So the first thing that you should do if you haven't already, and again, having somebody like Rod, you've already done this, but you need to make a list of all your assets. So you want to make sure that it's a listing of both like securities accounts, stocks, bonds, mutual funds, life insurance, but you also want to include the real estate in that list. And then it kind of gives you a good broad view, really, of what you're dealing with. And the other part of this list needs to indicate how the account is held, how the account is titled. So what I want to do, and I'm going to try to stop sharing this, come back to this. You guys will have to excuse me because I'm new at this, and then I'm going to pull this up. Dun, 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 dun. Going to go back to this. Maybe Zoom meeting. There's me. I'm going to share the screen. Gosh, I can't believe I'm actually doing this. It's amazing. Okay. So now that we know how the trust is titled and how we're supposed to deal with this, we're going to take this information and we are going to connect the different assets that we have. So we have our little list, and we're going to make sure that all our assets are connected up to our trust. So different assets are connected differently. So we're going to go through a quick little list here. Real property, if you have real estate, the real estate that you have needs to be owned by your trust. The trust is not a beneficiary on real estate. And that's the two basic ways that you would have the connection. Either it's an ownership connection or it's a beneficiary connection. So with real estate, it's always ownership. And you connect property, real property, to the trust by having a deed recorded with the county. And on that deed, it has your name as trustee of your trust. So the way that we hold title, that's the way we list it on the deed. And then that deed gets recorded. Now, I've seen some trusts and have dealt with some clients that think that just because they list the trust in the body of, or list the property, the name of the property in the body of their trust, that connects it up. So, having this list of things is helpful, but it doesn't make the trust work. What makes the trust work is wherever the account is, wherever the asset is, those records show ownership or beneficiary. So real estate, we use a deed. Checking account, the next one, with checking account, bank accounts, we really want the trust to be the owner. Now, in the past, I have told clients, well, if it's a small operating account, your salary goes in there, you pay your bills. If it's a small account, then it's no big deal. You don't really have to put that in the trust. You pass away, we can use a declaration within a few days and get access to it. The problem, though, these days, and this has changed a little bit, is it's not the death issue. So it's still pretty easy to deal with things if you pass away. But if you become incapacitated, if you're still alive and you become incapacitated and your checking account is just in your name, then we have to access that account, we have to use your power of attorney. And I'm sure that if you've done basic planning, you have a power of attorney. The problem, though, is the bank does not like to accept powers of attorney. I'm assuming it's some kind of liability issue, but they will do everything they can to convince you that your document's no good, or just to make it so hard that you go away. I mean, it really seems, I've dealt with at least 5 or 6 clients that have had these issues, and it just sort of seems like they do everything to get the client to do something else and not use their power of attorney. If the account is owned by the trust, however, You've gone to the bank. You've told them you had a trust. They even changed your records to show that the account is owned by the trust. So they kind of expect somebody other than you to show up at some time and access the account. So they don't have the same fear. They don't have the same resistance. So it's better nowadays if your bank accounts, even your little checking account, is owned by the trust. That's just my personal opinion. Okay, retirement accounts. So retirement accounts cannot be owned by your trust. Actually, your retirement account is owned by the custodian, which is the company that the account is with. So if you have an account, an IRA, B of A, then the technical owner is B of A. But they're acting as your custodian. And on retirement accounts, you always want to put your spouse first if you have a spouse. But sometimes we will put the trust as the secondary beneficiary on a retirement account. So spouse would be first, trust would be second. There used to be a little bit of controversy around using a trust on retirement accounts, dealing with the issue of taking the money out eventually after the person dies, and you want to be able to take it out as slowly as possible. And there were some people that thought that trusts required distribution to come out quicker, and therefore be more taxed sooner, that kind of thing. But that's kind of all gone away this year. They changed the rules, and everything is pretty much even. If you put the kid's name on as the beneficiary, or you put the trust name on as the beneficiary, it doesn't matter. You have 10 years to take the money out of your retirement account, an inherited retirement account like that. So, sometimes we need the trust, sometimes we don't. It just depends on your individual planning. Obviously, if you had minor children, they can't have anything in their name. So you would want a trust as a backup beneficiary on the retirement stuff for that. The next is securities accounts, and securities accounts pretty much work like checking accounts, where you want the owner to be the trust. You don't want to set up the securities accounts with individual beneficiaries on each account. You want everything to be in the trust so it's all together. I've have some clients that have multiple accounts where they just put individual names on it. So when I die, I want it to go to this person. It's a TOD account, transfer on death account. And you got to be careful when you do. I mean, that's okay for a few accounts, but we want to make sure that the trust has cash, has money in there to be able to pay for the expenses, whatever those expenses might be. We want money in the hands of the person that legally represents the estate, and that's going to be the successor trustee on the trust. If you put beneficiaries on all your accounts, the beneficiaries go and get the money, and then the trustee has nothing to pay the bills with, and they have to go and collect the money back from the beneficiaries, and if they even have it any longer. Sometimes that money goes away quickly. So all those accounts, all those securities accounts, and also the checking account needs to be owned by the trust. Next is life insurance. Now, life insurance, we can actually have the trust be the owner and the trust be the beneficiary on the policy. So again, this is something that depends on the kind of planning that you're doing and the kind of beneficiaries that you have. If you're trying to get monies to younger people or incapacitated, disabled people, you need a trust to do that. So you need a trust to be the beneficiary on the account for your minor children. You don't need Aunt Lucy to be the beneficiary because Aunt Lucy promises to use the money for the benefit of the kids. We want a trust on there so that the money goes into a trust for the kids. Aunt Lucy can manage the trust, but we want it separate from her own funds, just in case if she gets into financial trouble. We don't want the kids' money going to her creditors. And then annuities pretty much work the same way. You want the trust can be the owner, the trust can be the beneficiary, and it really all comes down to the kind of planning that you have, the kind of beneficiaries that you have. And again, this is, all of this, when I do this for clients, if I always ask, do they have a financial consultant, a financial advisor that they can talk to about this? Because this kind of stuff, dealing with the different institutions and the forms and all this stuff, is something that they do all the time. So I'm always pushing them. You guys are lucky you have somebody like Rod that is able to help out and make sure that your overall plan, you got to make sure the estate planning part fits with the financial planning part. And that really is Rod's job to make sure that happens. So, and he does a great job at it. So with that, I think I'm pretty much done.
All right. Well, listen, guys, that concludes this edition of Money Talks. Next month, we have a great lineup. We have Raymond James, part 2 of the Raymond James meeting will take place next week, and then next month, rather. And then we will also have, I believe we're going to have Layla Isatron back. She was the speaker, the therapist that we got some tremendous feedback on her presentation. Apparently, we all needed a little therapy last month, with the pandemic, being cooped up with our significant others. So we are going to have her. She's going to talk about transitioning back into, the workplace and into public places and so forth, and the fear that comes along with that. And she's going to deal with that from a therapist perspective. And so that we look forward to that. And then we're also going to have our market update for the balance of 2020. I'm going to talk about the sectors that our analysts feel represent the best, where the best opportunities are. And I was going to go over that today, but for the in the interest of time, we're going to push that back till next month. Okay, and we're also Adam's going to send out to each of you a copy of our outlook for 2020, and that'll give you some time to peruse through it. We have been rebalancing all of our clients, and those of you that I have not met with yet, just make sure that, to give us a call so we can get you scheduled for a review call. We've handled most of the review calls for the year, for this first portion of the year. We will be meeting with clients multiple times this year. I like to meet with clients at least 3 to 4 times this year as we get you through the recovery cycle and make sure that you're positioned for growth. This is the time that we look for the opportunities. We don't just focus on the depreciation in the markets, but we rather focus on the growth opportunities rather in the market. These opportunities come around every 6 to 10 years, and we want to fully take advantage of these opportunities. There are still lots of sectors out there that are still very much depreciated and represent some really good buying opportunities. We want to be prudent about it, and we at the same time we want to make sure that we take advantage of every opportunity that we have. So with that, you guys have been great, and we look forward to seeing you in the next, I believe, 2 weeks. But we're going to have, I think, 3 meetings this month. So we'll have one the 2nd, 3rd, and 4th Friday of the month, and you will receive emails by next week on the content and those and the start times. Okay. With that, everybody have a great weekend. Make sure you're washing your hands, and virtual hugs to everybody. We'll talk to you later. Bye-bye.